Attorney Pooja Mehta, and I am here on a live to talk to you guys about that new policy memo issued by USCIS on Friday, right before Memorial Day, right? Best time to push out a new policy change. So what I'm here to basically talk to you guys about is I want to let you know who's going to be impacted, who's not going to be impacted, and then for everybody else that's already filed a green card application or that's going to file a green card application, what do you need to do? So here's the gist. Let's jump into it. Number one, who's impacted? Everyone that's on a non-immigrant visa. So your H-1B, your tourist visa, your student F-1 visa. And the problem that these people are really going to face is, for example, if you're on an H-1 and now you have to file for your adjustment of status, or rather your stamping to be done for your green card through the embassy, you're now running a risk of whether or not your employer is going to keep your job or how that whole process is going to happen. Just because you go to the embassy doesn't actually mean it's going to get approved right away. It could take some time. It could take some days. We know that the problem with the embassies also is that you're going to most likely get a 221G if there's a problem in your file, meaning if there's a criminal issue, if there's some issue with respect to not being able to get your visa done properly, right? So if there were any gaps or there were any gray areas, we can expect that the 221Gs are going to be issued. And if you're on that H-1 and you have these substantial delays, what's going to happen to your job? Because you can't continue to work remotely from India, because the H-1 contract between the employer and the government is for that worker to be here in the United States and be working. So that's for the H-1. Student visas are going to see problems because if they leave for an interview and it impacts their study time frames, when they can leave and when they can't, they could be in violation of that student visa, which could then create bars to re-entry. So the issue is a lot more complicated than just honestly who fits into it and who doesn't fit into it, because for those individuals that fit into this policy, we also have to understand how it's going to impact, right? Third level of consequences, second level of consequences, meaning indirect consequences that we really weren't expecting. Now, let's talk about who's not impacted by this. If you're on asylum or if you're on a humanitarian visa like a WAWA or a T visa, a U visa, these individuals most likely are not going to have problems with their 485s. If those cases have been approved and they can continue with their work permits. But individuals who are not on a humanitarian visa, individuals that are on a non-immigrant visa are going to be seeing problems. Now, number three, what I promised we're going to get to real quick is what happens if you are in that first class of individuals on a non-immigrant visa and you need to now go and process this green card application. Well, you can either process it from the embassy, which is what USCIS wants, or you can then go through what's called the hardship waiver. So the policy memo has been really clear to say that if you show a hardship, you'll be able to potentially get a waiver for the interview in the embassies. No attorney, no person right now knows what that means, very honestly. But what we think it means is most of us have been doing 601 hardship waivers for years. I know my firm has been, and we understand extremely well the standard of review that's going to come up by USCIS when these hardship waivers are understood and reviewed by these immigration officers. Now, it's going to be everybody and everybody's mom that's going to be applying for these applications, right? So how do you stand out from the crowd? And that's what our job is going to be, to get you to stand out. Hi there, Sharon. To get you to stand out from the crowd and get that waiver approved. Right now, there's no form. So our presumption is it's just going to be an additional add-on to the adjustment application paperwork. But the reality is that could change. And if that changes, we take care of it. Not a big deal. But what we know is that hardship application is going to go over financial hardships, that it's going to go over mental health and physical disabilities. It's going to go over visa issues, right? So if you have already been here unlawfully and you leave the country and trigger a 10-year bar, well, that's a hardship. We need to talk about that. We also want to talk about how it's going to impact your U.S. citizen spouse, right? The intending immigrant is going to go through problems, but how does that impact the wife or the husband that's here in the United States? I was doing a consultation this morning with a lovely couple in the South, and essentially the wife is a U.S. citizen, grew up here her whole life, has no absolute idea how to move around in Africa. She grew up in this small rural community, and to ask her to go to this country and live her life there is just absolutely absurd. It's a significant hardship. So we would be attacking that from both points, not just what's going to be impacted to the intending immigrant, but also to their family, their loved ones, their children, their friends and family that are here in the United States. So stay with us. This is immigration attorney Pooja Mehta. I hope this gave you a lot of answers on what this new memo is going to be pushing. Now, there's a link in here, okay? There's a link here at the bottom of this video that you're going to get. There's a free webinar that we're doing today, May 26th at 5 p.m. to give you free information, answer your questions, help you guys get on the path to that hardship waiver, and help you really understand who qualifies and who doesn't qualify, okay? All right. Love you guys. I'll see you soon, and we'll talk to you really honestly anytime we get new information on this case. Bye, everyone.